Welcome to the podcast, Katherine Rayden. We're very excited to have you.
Thank you.
An absolute icon in family law, a female founding partner of a huge national law firm with, is it 9 offices that you've got?
9 offices, yeah.
Rapidly growing, big team. So we feel honoured to have such an industry expert to join us on the podcast today. I'm also joined by my colleague Max, who's a director at Level.
Hello.
And me speaking is Alexandra, director from Level as well. So the theme of the podcast today is common misconceptions in family law, and we're going to be put right by Katherine here. So we've come up with a list of the main ones, and all of these myths will get debunked by the expert. So Max, did you want to start with some of the misconceptions?
Sure. So firstly, we have cohabiting rights are the same as those of married couples. Many people believe that if you live together for a certain period, you automatically gain the same legal rights as married couples.
Yeah, I mean, that is a problem. There's a phrase that's quite often used called common law husband and common law wife. That was banned in the 17th century, and yet it still features in the newspapers. You have no rights as a cohabitee. You have rights if you have contributed money towards a house, and that's to do with trust law. And you have rights if you have had children, and that's to do with children law. But you don't have rights under any Cohabitation Act or as a status of cohabitee. And if you've given up your job and you've been together for 20 years with a promise of a pension, you have no rights. It's just a promise.
So very little protection.
Very little protection. And it's something that the Law Commission has talked about, but doesn't get any traction. And so the only message I can give is find out your rights and act accordingly.
And is this something that the law profession is looking to?
The Law Commission has said it, but the Law Commission has said it 2 or 3 times. The law profession can't do anything about it because it requires government. And every government has something else that they say is more important. But the Office of National Statistics now says that there are more children born out of wedlock to unmarried couples than there are married couples. So some might think it would be important, but until there's a change in the law, the key message is you have no rights as a cohabitee when your relationship breaks down.
And that's why we're seeing separation agreements, or hearing about separation agreements a lot more these days. What is a separation agreement?
A separation agreement is an agreement that says what you'd like to happen if you separate. And I don't mean to be glib about that, but that's literally all it is. It's not a binding document. The only use of it is that it records what the parties' intentions are.
Okay.
It's not particularly binding, particularly if you're a cohabitee. If you're married, it might have more weight, but what it can do is confirm that you've got a right under trust law, but it doesn't really resolve any legal rights.
And so cohabitation agreements, how are they different? Are they the same separation agreements, or are they their own?
One would normally do a cohabitation agreement at the beginning of your relationship when you're about to live together, and you might do that in order to limit somebody's claims under a trust. So you might say, we will each pay £1,000 into a joint account towards bills. And that will mean that the person who doesn't own the house won't have a claim on the house. So you're just structuring and providing a narrative as to why you're paying this money and what you expect to get out of it. And you might say, for example, if our relationship breaks down, you can carry on living here for 3 months or 6 months or 9 months. But it's just a record of what you agreed on the 3rd of September, and that's all it is.
Okay, no, that's really helpful. Max, what are other common misconceptions?
The next is mothers always get custody of the children. It's often assumed that mothers will always get custody of the children after a separation.
Yeah, so that's another phrase that's used a lot, custody. We haven't used custody now for about 25 odd years, but again, it still appears in newspapers, and it's a phrase used in different jurisdictions. The courts make a very big push to say that they don't see gender and they're gender neutral. And you can discuss that at another stage, whether that's ever the case. But the general trend at the moment is that courts are now looking for shared child arrangements orders, which means that in some way the father and the mother will share custody. Quite often a father will ask for 1 week on and 1 week off, i.e. 50-50 shared care. And that can be quite difficult for mothers who have spent their entire relationship doing all of the work for the children, and the father has been working and paying no attention to the kids apart from a Saturday afternoon, and he swans in wanting to be a full-on dad. But the court's view is whatever happened in the past is irrelevant. If he's capable of looking after the children, he should do so. So fathers should feel empowered that they will get to see their children far more than perhaps they did during the relationship. Mothers should be aware that there is no automatic bias towards them in terms of granting them custody. The courts are very clear that parents have a joint responsibility towards their children and they should be equally involved.
Great.
Third, we have divorce settlements are always split 50-50. People commonly think that assets are always divided equally between spouses during a divorce.
Yeah, I'm surprised you think that. Because lots of people also think that you should get more money if you've got the children, or if your husband's committed adultery, you should get an extra amount. I think recent family law, this is the one bit the newspapers might have got right, have emphasised a 50-50 split. So I hope that most clients know that the starting point is 50-50, but the actual way that the assets will be determined will be based on a number of factors. Based on a statute that was made in 1973, you might get 50% if it's a long marriage and you've both made an equal contribution. You might get a lot less if it's a short marriage and you haven't paid anything towards the marital home. You might get a lot more if there's not many assets and you're the primary carer of 3 or 4 children and you need to retain the house in order to provide for the children. So it's not automatically, but it's a fairly good guide. And really, truly, not many people, after a long marriage, veer much further away from that anymore. I mean, sometimes it's 60%, but generally it's around the 50% mark.
So what you're saying to those people out there who've married a wealthy man or woman for a year, you're saying that they don't automatically receive 50% of the other person's wealth.
No. And there's a case going on at the moment where it was a long marriage. She married a wealthy man. It's called Standish and Standish. She didn't get half either because that was a second marriage for him. He already had quite a lot of money beforehand. So, and I appreciate lawyers always talk about these sort of things, but when you say 50%, Standish says that wives get 50% of the marital assets.
Yeah.
And so you might have a case where the total assets are 100 million, but the courts have decided that the marital assets are 40 million, and so the wife gets 20 million. So in one sense, she's only had 20% of the assets, but in another sense, she's had 50%. So, and I know lawyers play around with wording, but that's what we do.
Yeah, no, that's really interesting. Thank you.
And so the UK courts, they start from a more fair position than perhaps some of the other jurisdictions.
Depends who you're acting for, doesn't it? And it would be the English courts.
English courts.
Because the Scottish courts have a very different view of looking at things.
Yes.
Yeah.
So I'm an English family lawyer and I think our system is pretty fair. But if I was acting for somebody who had a choice of jurisdictions, I might tell them to go somewhere else. There's a big push at the moment as to whether people should aim for fairness or certainty. There's an argument that Scottish law is fairer because it's certain. You won't get much money, but at least you'll know what you'll get. And that's a big push with Baroness Deach and Baroness Shackleton. But who knows whether it's fair or not, definitely is in the eye of the receiver, I think.
Definitely.
Or the payer.
Another common misconception that's relevant to us as well as you is that the wealthier party will have to pay my legal fees if I can't afford it. At that very first meeting with the client, you address how much it's going to cost with them. What sort of conversation do you have with them about how they're going to pay their fees?
I think it's really important that you have that first meeting and you do discuss the total costs and how you're going to pay it. We do have that discussion, whether they have money of their own or whether they can apply for litigation funding. It may well be that the wealthier party will pay your fees, but that's at the end of the proceedings, and proceedings can take 2 or 3 years. Most law firms want to be paid on a monthly basis. They've got bills to pay themselves and salaries to pay. And it's really important to discuss at the very first meeting how the legal fee is going to be paid. A lawyer can't guarantee how much the cost can be, but if they get a sense that the case is going to cost, worst case scenario, £75,000 to £100,000, and the parties are arguing over 75 to 200, then it's not worth arguing.
Yeah.
Equally, if the person doesn't have any spare cash and there's a fight worth having, there needs to be a discussion right at the beginning, before all the litigation kicks off, as to how the fees are going to be paid and when they're going to be paid, which is when I normally call you, Alex.
So, yeah, I think I wanted to just touch on the different options available to clients out there. Not all of them, including funding, but sort of go through them one by one. Option number one is obviously self-funding. So the benefits of self-funding are obviously no interest payable, which is good. And, you know, there's no delays. You can crack on immediately and get on with the litigation. Option two is borrowing from friends and family. So I'll let you talk about the positives and negatives of this.
In family law, we talk about soft loans and hard loans. A lot of people are concerned about the interest rate and arrangement fees. Quite often, family members will find money, maybe from a pension pot or something they were saving for in the future, and give money to their family member to help with litigation, which is really nice of them. And they will say, when you get your money, can you pay me back? I would probably say that's about 50-50 chance of getting it back. But the bottom line is it's very discretionary, and the courts will decide whether they should put that into the asset schedule, and it might involve quite an intrusive investigation into whether the family member has any other money, whether they can afford it. And the judge might decide this £20,000 that your aunt gave you is just an advance on inheritance, and I've decided it's a gift.
Right.
Which may come as some surprise to the aunt, who thought she was giving away her retirement fund just for a few years until it came back.
Yeah, so it's risky.
It's really risky. The advantage, obviously, is that doesn't charge interest. It's ready funds. But I think there has to be a very clear conversation between the family member and the borrower that you can have a go at getting the money back, but if it's actually a gift, the courts are going to view it as a gift.
And just to be clear here, when you say getting it back, we're talking about settlement when the judge or whoever else is deciding how the assets are divided. You mean the amount that's been used for legal fees comes from the sale of the house, let's say, or from out of the cash that's up for division. So it's essentially repaid or not is what we mean when we say getting it back.
Exactly. And when you have assets and they're divided, the question is, will those legal fees be taken off before the remaining pot is divided or not? And if they're not, then instead of having a housing fund of £600,000, you might suddenly find that you're liable to pay your own legal fees, and your £600,000 settlement becomes £550,000 because the court's assumed that you're responsible for paying it back.
Yeah, no, that's really clear. Thank you. And then obviously other options available to us. We've got high street lending, taking a loan out from a bank. Again, I'm assuming it's a similar situation, 50-50, if the court's going to decide whether or not that's something that's going to have to be top sliced?
No, I'd say if you're borrowing from a third-party lender, then I think you've got a fairly good chance of getting that paid from the top. The problem with high street banks is that they will tend to only lend to people who have assets in their sole name, and they will normally want it as a secured loan. It's very difficult to get non-status mortgages anymore. Overdrafts tend to be limited to a few £1,000s. You'd have to have an asset in your sole name that you could put as security. And generally, in my experience, and I don't have much because not many of my clients do it, but the banks tend to want a long-term repayment loan. So they prefer, their system is set up for mortgages. So they'll give you a 5-year mortgage or a 2-year mortgage, which although might have a lower interest rate, if you pay it over 5 years, your total interest might be quite high. Fine, if it's available, but I just don't see it available that often.
Especially in cases where the person needing funding is the one who doesn't have assets in their own name, the weaker financial party. So
Yes.
it's pretty exclusive. If somebody is needing funding, then they're not going to be in a strong financial position usually. So another option is obviously that the other side pays the costs. How common is it that the other side agrees in a divorce?
My firm are quite cheap, so we can often get funding from the other side, but it really depends. What the problem is, what tends to happen is that if you agree litigation funding from the other side, say you said we need between £50,000 and £80,000, the other side will say, well, you can have £45,000, and then you're put on strict controls by the other side. So you might think, well, I'll give you a lower end estimate on the basis that everything's agreed quickly and we don't have to make any extra applications. As soon as that doesn't happen and you have to make a few extra applications to the court or something gets delayed, the costs go up. And if it's a contentious case, a lot of people feel that being funded from the other side is a form of control. I think, personally, there should be a law that says the other side pays as you go along. It absolutely should pay for every pound that the wealthy party spends in legal fees, they should pay £1 to the wife. But my opinion is worth absolutely zero. And it's the courts that matter. And the courts don't have that view. So you're left in a situation, will the other side say yes or will they say no? And if they say no, there's nothing you can do about it. You can say please, you can ask again, but it's absolutely up to them whether they pay or not. And so I would say the chances of getting the other side to pay is less than 50%. It's quite low.
And then that brings us on to what we do, which is litigation funding. So if you've explored all of the options we've already discussed and they aren't viable options for you, then obviously litigation funding is something that you can discuss with your solicitor and your solicitor can in turn discuss with us. So litigation funding, how often would you say it's used in terms of a percentage of cases that you're either working on yourself or that you're on the other side of?
I think it's used in quite a lot of our cases. In terms of percentage of cases we use it on, probably not that many, but that's because we do 1,000, 1,500 cases a year. But of the cases that go to litigation and trial, I would say litigation funding features in 70, 75% of the cases, because many people are asset rich and cash poor. And so they can afford to fight this case. They might have a really important issue, but they just don't have the cash to fund it until that jointly owned asset, normally the house, is sold. If you're going to trial and if the case is not settled within 6 months, then I would say most of our cases have some litigation funding, either from our client or the other side.
Understood. If litigation funders can't help, the next stage is we reject the case. We confirm that in writing to you and to the client. But you can go for what's called an LSPO application. Did you want to tell us what that is, Katherine?
It's called a Legal Services Provision Order, I think. And that is an order whereby the other side are required to pay legal fees towards their former spouse or former partner. There are some parties that don't pay the fees, but it's the only option available sometimes if you can't have any other route. And one of the requirements, if you are going to make an application to the court for LASBO, as the lawyers call it, is that you must be able to persuade the court that there is virtually no other option. And it is your option of last resort, and it's as good or bad as any other last option is.
Yeah, no, that's really helpful. And I think it's worth mentioning, if you are a listener who is assessing their options, it's definitely worth discussing each of the options with your solicitor so that you can make an informed decision on what's best for your case. Obviously, each comes with its positives and negatives, but also different forms of financing being used tactically throughout cases. So it's definitely worth going into detail with your solicitor. Another misconception, this one comes up all the time. I get asked about it by friends, family, just people when they find out what I do for a living, and I'm sure you have the same. You need to prove adultery or fault to get divorced.
Yes, that has only been a misconception since April 2022. Before that, we had a fault-based divorce system. Now we have a no-fault divorce system, which means that the reason for the marriage breakdown is no longer required. And so you don't have to prove adultery and you don't have to prove fault at all. And so the government and many family lawyers think this is a great move forward. What it means is that the cause of the marriage is no longer a relevant factor to the court, which is a good step in terms of divorce, and it makes the process quicker. However, some people don't feel that they've had their sense of closure, and whilst they might feel really hurt that a 20-year marriage has been brought to an end by some egregious behaviour from their former spouse, it is rare now for that behaviour to be known about by the court, commented upon, or more importantly, resulting in more money.
Yeah. And then this one, again, another juicy one. People like to talk about this. Hollywood likes to make reference to these all the time in their films and TV shows, but prenuptial agreements aren't legally binding.
In this country, that's true. There is no law that says prenuptial agreements are going to be wholly upheld. They are an agreement, and it's an agreement between the parties that say, we've thought about this carefully, we've discussed our financial position, and if we get divorced, this is the financial provision we would like to make. Although they're not absolutely binding, if a good prenuptial agreement has been drafted by lawyers who've drafted it properly, who've made it clear, given everybody a chance to negotiate, and there's full and frank disclosure, it is more likely than not the courts are going to uphold at least some of the agreement if they think it's fair. And there's a lot of case law at the moment where judges have said, if it wasn't for this agreement, the spouse would have got X, but because this agreement is in place, I'm now going to reduce the award to a smaller amount. But in this country, they're not wholly binding, but they are really important part of the party's finances. And so, as with everything, you shouldn't sign anything unless you know what you're signing, and you shouldn't sign anything if you don't think it's fair.
Yeah. And so just then going into a little bit more detail on prenups, what makes a good and a bad prenup?
A bad prenup is one that doesn't give fair provision to one of the spouses. It can give a zero award and it's not fit for purpose. It could be signed too close to the marriage. The Law Commission had suggested in a white paper that all prenups should be signed 28 days before a marriage or a wedding. I have actually found that is a date that can cause problems, and I would actually rather my clients signed it 21 days before a wedding, if that extra week gives them time to pause and reflect, than feel that it's a hard deadline. Another problem is if the prenuptial agreement is so focused on the parties' arrangements as they got married, it doesn't really cater for the situation after they've had children, for example, or when one of the spouses has given up work Another bad prenup would be one that attempts to bind a court of another jurisdiction without taking that foreign law advice.
Okay.
There's lots of stories in America about conduct being relevant, but that wouldn't hold water here. There's one prenup where the American lawyer says that the wealthy man said that for every £10 his wife gained, she would get $10,000 less.
Wow.
But that would definitely not be upheld in this country.
No, I'm not surprised. But no, that's really helpful. Thank you, Catherine. And last few, maintenance payments are for life. Some people think that spousal maintenance, also known as alimony, is always awarded for life.
Not in this country. It used to be the case. England earned the reputation of providing wives with a meal ticket for life. That's definitely not the case now. It never used to be the case up north, but it definitely used to be the case in London. But there's recent case law that's made it clear that's not going to be happening. The courts will expect the recipient spouse, let's call them the wives, to make an effort to find financial independence. They won't expect them to earn the same amount as the husband, and they won't be surprised if the wife experiences some loss of lifestyle. But generally speaking, the term of maintenance is getting shorter and shorter in this country. There's no definite law about it. The law makes it clear that it's possible to have it for the rest of your life, but in practice, it tends to reduce over time.
A common misconception is that you must go to court to settle family disputes. Many people believe that court is the only way to resolve disputes such as divorce or children issues.
Taking the children issues first, the statute says that there shouldn't be a court order made about children unless it's absolutely in the children's best interests. It's enshrined in law that court is the last place you should go when talking about children issues. There's lots of really useful information on the Resolution website or CAFCAS website about drawing up a parenting plan. Mediators can be really good dealing with different parenting styles. And generally speaking, the best people to determine what happens to a child are the parents. If that can't happen, then a judge who's probably never met the child will make decisions about that child's welfare. In terms of a financial settlement in a divorce, there is a misconception about that, because lawyers will tell you, and they're right, that the only way to have a binding financial settlement upon divorce is to have a court order. That means the financial agreement has to be approved by a judge. But that shouldn't mean attending court. It can just be a couple of emails, literally these days, where you lodge your agreement in a quiet form, send it to the judge, and the judge will stamp it. Generally speaking, the vast majority of cases do not end up in court in terms of contested proceedings, but there is a court order. The cases that end up going to court, generally only two types of cases. There's a dispute as to the extent of the assets, or there's a dispute as to principal. So you might say, well, I absolutely agree that there's this amount of money, but I have a fundamental objection to the house being sold, or my bonus being shared, or the pensions being split. And those are the cases that go to court. Or you'll have people that say, I absolutely don't agree that we've only got £1 million worth of assets because how's he afforded that car, watch, plane, what have you. And those are the only cases that go to court. Disputes as to principal and disputes as to assets.
Yeah. Okay, well, Katie, thank you so much for helping us debunk these common misconceptions. It's been a real pleasure having you on the podcast and to hear what you have to say. And if people were to want to contact you or your firm to ask any additional questions, what's the best way for them to do that?
Our website has quite a lot of resources, www.raydensolicitors.co.uk, but you can always call us as well.
Amazing. Thank you so much, Katie.
Not at all. Thank you. Bye-bye.